Okay, Deb, it's 3 o'clock if you want to get started.
Thanks, EJ. Well, for those that were at the last session, I think as we kicked off the conference, we mentioned the need to be adaptable and nimble in today's environment. And so appreciate taking that to put it into practice as we had to shift very quickly, and appreciate, CJ and Caitlin, everyone shifting over to Zoom. Certainly unexpected, but it's befitting of 2020. In terms of that session, our understanding and goal is that it will be recorded and then posted at a later date. So all is not lost, but it may be delayed. And now, as we move forward in the afternoon, I'm reminded at the end of Trading Places of turning the machines back on. With that plea, we will go ahead and get started with session 3 for the day. Before I jump in and make an introduction, I do want to make a very quick couple of mentions. One, with respect to the CLE credit, again, make sure to turn in your attendance form no later than Monday, October 19th, if you're viewing it live. And then also, as mentioned earlier, after this session, later this afternoon, there'll be a virtual wine tasting. So hopefully people have had an opportunity to sign up and register with or without wine. It would be a good networking event. So without further ado, I am going to introduce the next panel. The next panel is the new normal of working from home. We've all been forced to, with the pandemic, work remotely. Typically we would focus on the operational and logistical issues to ensure that work is being performed efficiently, given the ever-changing demands. As part of that, as we all know, there's professional responsibility requirements that have to be adhered to when working either in the office or working remote, but in particular remotely. This panel is going to touch upon some of the ethical issues facing businesses and attorneys in today's environment, including issues with outsourcing legal services and cybersecurity. The panel will be moderated by Deborah Winokur. Deborah serves as Professional Responsibility Counsel and is a member of the Legal Professional Services Group at Cozen O'Connor. Deborah advises clients on risk management and ethical issues. In addition to her work at Cozen O'Connor and numerous pro bono representations, Deborah also is a lecturer in law at the University of Pennsylvania Carey Law School, where she teaches professional responsibility. Now I'm going to turn it over to Deborah to introduce her panel and start the presentation. Deborah.
Thanks so much, Michael, for such a kind invitation or introduction. And CJ and Caitlin, thank you for managing all of this and for all your quick action and support all the way through. We really appreciate you having us here and getting the chance to talk about this really important subject on the new normal of working from home. We couldn't have asked for a better setup than the current one, as we are making very quick adjustments in order to meet with you here today. So we will be talking about exactly these kinds of issues that we experienced. And I know Caitlin is setting up polling questions for us. But if we're not able, we'd love to hear from you and hear, see what people are thinking, but, we'll try to be flexible on that. So a huge thank you to all of you for being here, and particularly to Keturah and Diana for joining us. And with that, I'd like to turn it over first to Diana and then to Keturah.
Thanks, Deb. I am Diana Ashton. I am the General Counsel at Finnegan. And like Deb, I also teach at the University of Pennsylvania Carey Law School. I have served on various ethics committees, the Professional Guidance Committee in Philadelphia. I was the chair of the Professional Responsibility Committee in Philadelphia as well. I have experience in conflicts, both the clearance, but also from the ethical side, in terms of, again, advising lawyers on paths forward, if you will, and also dealing with compliance issues within law firm settings. So I've worked at several large law firms in Philadelphia, one in Kansas City, and now I have moved to Washington, D.C. And Keturah.
All right, thanks. My name is Keturah Pestel, and I am the Director of Business Ethics at Thrivent. I've been working in the ethics space since 2005. And my role, I really look at it as operating in the currency of trust. without trust, it's really hard to get anything done. I'm sure all of you have experienced things where there's a lack of trust, and that makes it hard to get things done without a huge emotional investment. My business responsibilities include managing our internal and external hotlines, measuring our ethics culture, communication and training regarding the ethics, and then also investigations and remediation.
So you already met me, and the one thing I will mention about my voice is that what I didn't mention earlier, I know we have people potentially filtering in as we're moving platforms, but I wanted to let you know at about 20 minutes in and then 40 minutes in, I will be announcing the conference codes for your CLE credit. I believe I'm allowed to say them twice, and that's it. But for those of you who might have popped in late, they won't come until about 20 minutes and 40 minutes in, so you haven't missed your opportunity to get CLE credit. Okay, so just kind of starting off, I wanted to ask both you, Diana, and Keturah, were you ready for COVID-19 and working from home?
Well, I'll go first. I will say I certainly wasn't. I just recently joined Finnegan in the last week of January. And as I've sort of joked about, though it's no joke, that of all the 30, 40 interviews I had, not once did someone ask me about my experience leading a firm through a pandemic. So it was certainly, I was learning as I went. I think a lot of us were. But I will say that it goes back to a lot of those tabletop scenarios, those disaster scenarios that I've always been a part of. It's in various firms run through different departments, whether it's the IT department, which is where I've mostly had these disasters of what happens if every server in the firm goes down? What happens if there's an explosion and we can't access certain buildings? And so I will say that if any of you have gone through those tabletop exercises, that this was something for me that immediately got me into what are our capabilities for remote work? What do we have? What do we need to have? What are we thinking about? And are we ready for COVID-19? Part of me is also saying, am I ready to go back into the firm? Because there's going to be as many steps to get back into these buildings. I think many more than when we left. But Keturah, how about for you? Were you ready for COVID-19?
I did not see a pandemic coming. I have learned some family history about the 1918 pandemic, in which my ancestors dealt with something that was unexpected to them too. So I feel like I'm following in their footsteps a bit and pivoting. But we weren't ready exactly. Like you, we have tabletop exercises. And so I think that what helped is a lot of those kinds of principles, things about caring for our people, things about putting a response team together. We fortunately had just launched Teams very shortly before we all were sent home, and that was great. I was just talking with somebody yesterday. Can you imagine if this pandemic had happened 20 years ago and voicemail was the new amazing technology available? It would have been much harder than the tools and resources that we have now. But I also think one of the things that I was really happy about that we were ready for is not only did we have those kind of table stakes in, but we were looking ahead with our response team to other things like mental health resources. How can we make sure that we have not just the baseline of technology available, but emotional support resources available for people too, because I think that's really critical for people to be able to do their best work and balance and manage all the things that we're having to deal with working out of our bedrooms.
Yeah, that's interesting. And I know we're going to come back to those themes, and we could probably talk for hours about the tabletop exercises and the importance of them. Not always easy to get folks in a room to go through those, but those are really so important. Okay. So in Pennsylvania, we were kind of in a similar spot as far as not really foreseeing this issue and not having a lot of guidance out there on what to do in a remote work environment. So the situation we faced is Pennsylvania, we're a big state. We've got 2 large cities. We just had a football game, Pittsburgh Steelers, Philadelphia Eagles. We did not come out in Philadelphia on the winning side of that one. But anyhow, in between these 2 large cities, we have large, swaths of smaller towns with smaller to mid-size and solo law firms. And they were really wondering, they didn't have the same infrastructure as some of the larger firms. I think the scale can create its own issues, but they really wanted advice about how do we do this and how do we practice ethically. And so one of the places they turned was to, the lawyers turned was to the Pennsylvania Bar Association. And in April 10 of 2020, we issued Formal Opinion 2020-300 on ethical obligations for lawyers working remotely. I know we are obviously a national group here, but this opinion was the first one to come out and gets cited a lot nationally, and a lot of the considerations have universal application. And we are going to focus on what the model rules are. Of course, the rules in your jurisdiction may or could differ, so you're going to need to check your own state's rules. But these are the model rules so that we can talk of general application. So one of the key themes that comes up a lot and that we're going to talk a lot about this afternoon is confidentiality of information. And of course, that is one of the keystones of the attorney-client relationship. And that is covered by Rule 1.6 and confidentiality of information. So as a kickoff to starting to think about this, I wanted to pose the following, and here is the model rule. Give you a minute to look at it, but it is in your materials. So the first polling question is, would a lawyer violate Rule 1.6 if she copied her client on an email to opposing counsel and the client responded with information that is confidential and privileged? So this is the client responding rather than the lawyer. Oh, we cannot vote. Okay. And is anyone seeing any of the polling data?
Yes, people are polling, Deb. Let's see, we've got about 65% with no, 26% with maybe, and about 10% with yes.
Okay. Okay, interesting. All right. So I'm going to go ahead and look at, so I thought just being lawyers, we would all vote maybe just because it always feels like the safest, or maybe I feel like that's what our students always just do because they don't want to be wrong. So the answer is, at least in some cases, it's maybe. And in the Charm case, which is cited here, that was a case where that was a Massachusetts Superior Court case. And the judge was very concerned about the fact that the lawyer emailed his client on an email that went to opposing counsel, to co-counsel, and to other third parties. And the client responded back with information that he should not have shared that was confidential and privileged. And the judge said that could, create the lawyer's action in sending that could create a foreseeable risk that confidential information would be disclosed, and that is a possible violation of 1.6D, which says that a lawyer has to make reasonable efforts to prevent the inadvertent disclosure of confidential information. For those of you who are litigators, you probably think of it, and that was sort of the context that the judge in the Charm case compared this against, about the inadvertent production. But they said that not only does 1.6D apply to, large-scale document productions, but it also applies when the lawyer should really stop and think about, what's going to happen when my client receives this. If he responds to everyone with information that's confidential, that's going to be a problem. And I as the lawyer could be violating 1.6D. Now, in that case, the judge did kind of use a balancing approach and did claw back the privileged information. But it is the type of thing that I think keeps lawyers up at night, because not only can we get in trouble for what we do to disclose confidential information, but now we're also have to worry about our clients inadvertently disclosing confidential information. So hopefully, maybe the wine hour after this will balance out whatever anxiety the Charm case might give you. Okay, so moving on to competence, which was the other theme area that came up in our opinion 202300, we looked carefully about the role of competence when you're working from home and as it relates to working with technology. So, and as the quote here, and I guess my view of it, any sufficiently advanced technology is indistinguishable from magic. Unfortunately, under comment 8, which is a newer comment and is adopted in many jurisdictions, but the ABA adopted it, lawyers are required to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So in terms of Formal Opinion 202300, we emphasize that attorneys must secure paper and electronic files and ensure privacy during communications with clients, such as telephone calls or video conferences. The opinion also reaffirms the conclusions of 2 earlier Pennsylvania opinions relating to technology. These opinions provided guidance to attorneys about their ethical obligations when using software and other technology to access confidential and sensitive information from outside their physical offices, including when they operated their firms as virtual law offices. So one of the conclusions of the earlier opinion was that an attorney may ethically allow client confidential information to be stored in the cloud, provided that the attorney takes reasonable care to assure that all materials remain confidential, and 2, reasonable safeguards are employed to ensure that data is protected from breaches, data loss, and other risks. As far as virtual law offices, sometimes referred to as VLOs, in Pennsylvania, we said that an attorney can operate a VLO from his or her home, and that he or she can also work with associates who work from their offices, which may be outside of Pennsylvania. We also said that one of the concerns here is that you're not meeting face-to-face with clients, so any attorney operating a VLO must take appropriate safeguards to make sure that they're confirming the identity of clients and others, and that they're addressing circumstances in which a client may have diminished capacity. And then the opinion then highlights the rules of professional conduct implicated when working at home or other locations outside of a traditional office. And these rules include competence, confidentiality, supervisory responsibilities of lawyers and non-lawyer assistants. Finally, the opinion states that attorneys should take reasonable precautions to conduct all communications in a manner that minimizes the risk of inadvertent disclosure of confidential information, one of the areas we just talked about, that information is transmitted over the internet in a manner that ensures confidentiality, that remote workspaces are designed to prevent the disclosure of confidential information in paper or electronic form, that proper procedures are used to secure and back up client confidential information stored on electronic devices such as cell phones or in the cloud, and that any remote working staff are educated about and have the resources to make their work compliant with the rules. And they must use appropriate forms of data security. The last note I wanted to add about this opinion is that we specifically did not make recommendations about how exactly what was required in order to comply with the rules. So failing to comply with the best practices as described in the opinion doesn't necessarily constitute a violation of the rules. But if you do generally follow the recommendations, that's a good argument that you are complying with the rules, and that any question about your efforts there is covered. So moving forward a little bit. So our second polling question is, in an emergency situation, may a lawyer provide assistance in an area in which he is not skilled? And do we have a sense of, we're getting some polling data? Oh, okay. Oh, beautiful. Okay. All right. Yep, maybe is a a good answer. Yeah, and I mean, I think these are good answers. I mean, this is a tough question, and this is something that we are seeing a lot of right now, that people are facing areas where they weren't necessarily skilled. So under comment 3 to ABA Model Rule 1, there is some leeway for an emergency situation. And the comment says that in an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation or association with another lawyer would be impractical. So I think that there, was probably more leeway in the earlier moments of COVID, when everything was an emergency. As we're kind of in this indefinite holding pattern, I'm not sure, so I would agree with those who said maybe there may be some justification, but we can also take steps, and I would recommend that you start taking steps to start preparing so that you can address these emergency situations and feel a little bit more skilled. So there are some new areas where, trial lawyers have to weigh the benefit of taking a remote deposition and not getting to personally interact with a witness, or, possibly taking a deposition in person, but have your witness wear a mask and not get to see their facial expression. You may also have to consider the benefit of proceeding with a bench trial versus waiting for a jury trial. I mean, in Pennsylvania, we're a year and a half, at least a year and a half delayed on jury trials. So, there are a lot of, new considerations. The other thing is, along with strategy, lawyers are faced with understanding not only how remote deposition technology works, but also how it differs from conventional in-person depositions. So what I would say is that, take some steps to get up to speed on the new issues. I mean, we are somewhat inundated on these types of things, but on the new issues related to COVID in your industry and in your practice area. Obviously, attending industry or CLE conferences on emerging topics is a good idea. Potentially divide research on new COVID-19 laws and guidelines within practice groups, and have someone in your firm monitor daily the relevant state and federal court websites for rule changes and other emergent announcements. Would all be good ideas to try to address the level of emergencies that we're seeing. Okay, as we move on to security, I want to turn it over, I think, first to Diana to talk a little bit about security, and then to Keturah, and I'm happy to advance the slides if you just tell me when.
Thanks, Deb. That's great. Actually, I wanted, before we move on, I think one thing that we talked about, the three of us, and I think it's a good idea because, Deb, you and I were focused, primarily in our jobs on the ethics, on working with lawyers. And some of my concerns when I think about, for example, security or remote working are working with clients such as Thrivent and what Keturah is. But we get these outside counsel guidelines that tell us what our security systems need to be. And, so that's another lens to look at it. But then there's yet another lens, which is, when you're working at a non-law firm, how does this all work? How does this working from home? And I think we're so blessed to have another perspective. So I want to sort of talk about these two lenses. And I think, Keturah, if you want to jump in, and because ours is going to be primarily the ethics, but I think it's really important for everyone on this webinar to understand that there's a second side to how you look at all of these issues.
Mm-hmm. When I talk about it, so I'm embedded in the general counsel's office, but on the compliance side, I'm not a lawyer, but I work with a lot of them. And what I've noticed is a lot of times the law lens perspective seems to be focused on the what can we do or can't we do, what are the hard boundaries, and that's a really important perspective because of course you need to know what is a clear guideline of a can't or a should or a must. I think a lot of times people who are in the compliance and the ethics space look at what should you do, and that may be more than what the law requires. It may be applying the law in a different way than just a knee-jerk reaction is. And so that's something that I always like to think about of, okay, so here's what we can do. What should we do? does that change anything? Does that have us pull back a little bit differently? Does that have us talk a little bit differently, train a little bit differently, to make sure that we get the shoulds? And I think some of what I'll share later gets to the how should we do this piece of things too.
Absolutely. And security is interesting because when we're talking about even the rules themselves and how they have to change with technology. I mean, when the rules were, in 1980, all of the rules referred to client phone calls. And I think we talked about, voicemails as being potentially what could have been used if we, weren't where we are now with technology and all these webinars. And just thinking about how technology has advanced, the rules themselves, the ethical rules, have tried to really keep up with the security issue. And one of the, and we'll get into some of the statistics, but the bottom line is there have been an increased amount of hackings. It's gone from, I think, 4,000 attempts a month to over 30,000 attempts a month, because everyone knows that you're working from home. And so you're lawyers, I always say this, we tend to be, we have our routine, right? We come in, we have our routine. The biggest thing for me that when we went remote was how are folks going to adjust to their routine, and how are folks, we have our checklist, we have our way of operating and what we do, who we talk to first, where we sit down. It's often a part of the law. And so disrupting that in terms of security, right? When you go into the office, you feel very secure. You don't have to worry about, what computer you're using, how you're sending files. You have this infrastructure and whole team of folks that are out there making sure that security is intact. But as you move to your home environment, that changes a lot. So security has been a focus in terms of the ethical obligations, risk management, and malpractice concerns since really 1999. And there was the first ABA formal opinion that really talked about whether you could use an unencrypted email account to speak with your clients. And at this time, we're talking about Yahoo and Hotmail and AOL and those sorts of emails. And there was a concern, is this secure? Well, in 1999, they said it was secure. As long as the technology itself was doing its best to secure the information, then you could use it. But since that point of can I use email, cybersecurity has gone from, will it happen? Will something bad happen to when is that bad thing going to happen? So 10 years later, the ABA adopted its technology amendments and added obligations directly related to technology and competency around using technology. The changes were found in the rules, just to go over just a few of them so you can imagine how much changed with technology. It was the comments to Rule 1.0, 1.1, 1.4, 1.6, 4.4, and it went from, using mentions of benefits and risks associated, it went from telephone calls and responding to voicemails to benefits and risks associated with relevant technology. Because, by 2010, everyone understands we shouldn't even work for the technology of today. There's going to be technology far advanced from 2010. So now it's just relevant technology. So it's a broad term, but it has a lot of obligations that you, as you're moving home, are still under every obligation to fulfill. So in 2011, the ABA had an opinion that dealt with, and this is just an example, email communications with one's client. Something that, was not about the encryption, but actually about, for example, if you're this is an example of an employment lawyer who was sending emails to her client, and the client was responding, and it was about a workplace disagreement, and the client was actually using her workplace laptop and email. And so, I'm sure that all of us, when we log onto our laptop, you get that little screen that says, this is the property of your employer and what that entails. And so the ABA found the lawyer was actually acting unethical, that the lawyer didn't understand that you cannot send client confidential information to a client at their work email, especially when the emails were about how that workplace might be violating the client's rights. Katori, you must have a discussion about ownership of emails and the property. Is that something that you see in your office a lot?
Yep,
questions around
sure. We have annual training that goes over our policies and the core parts, and so we disclose, and everybody has to agree that they understand that we monitor and retain. Obviously, financial services, there's a lot of those regulations that govern what we have to monitor and retain. So we do have that. And I think people generally know about it, but for me on the investigation side, sometimes convenient in that they forget about it. So they put a lot of things in IMs and emails that are useful to me in understanding the truth, and they may wish that they hadn't documented. The other thing that I was thinking about when you were talking is it's not even technology necessarily with this at-home environment. It's very decidedly low-tech things like a child who, this happened to me, a child who gets stung by a wasp, runs upstairs crying and bursts into the room when I'm on a meeting. That's a very real need, despite the fact that we had childcare provider. You know, a kid who gets stung wants their mom. At the same time, I'm talking to somebody potentially in a confidential information kind of a situation. So what do you do when you're in these shared spaces, the bedrooms, the kitchens, the living rooms, with information that you're hearing and maybe have printed out, or documents that you have when you're in a shared space with people who aren't part of your actual work environment?
Right. And so how did you navigate that?
And
how do you recommend to others? Yeah.
Yeah, I paused the situation. So I think one of the benefits of COVID is maybe that we're all realizing we have a life outside of work, and everybody gets a little bit more grace, whether it's the yipping dog or the child who needs a bit of care. So I just said, excuse me one moment. The confidential information paused, dealt with it briefly, got her back, you know, bandaged up a little bit and back to the child care provider, and then resumed the confidential conversation. I've got in my bedroom / office, I've got a box, and that's where I put confidential info. And I've realized that I need to print a lot less than I did when I was at the office. I actually can manage on a screen. So those are some ways that I've addressed it. I think in terms of reminding people of their obligations, for the groups that have those kinds of confidential conversations, we've encouraged leaders to have conversations with their staff to remind them. And also our regular annual training period happened to be over the summer. So that was good timing to just remind everybody of their obligations as well.
That's great timing. And so 2 things, Deb, I'm going to let you read the code, but just to wrap up security, you know, a lot of jurisdictions on the ethical side, like for example, in Florida, they're actually mandating that attorneys take technology specific CLEs so they can learn about, you know, whether it's using Zoom or how to email, or, you know, how to protect confidential information when you're at a coffee shop. And so it's really helpful. And I think a lot more jurisdictions in the future are going to be probably mandating the technology-driven CLEs that we can switch up. And if you want to give that code as well.
Yeah, sure. No, let me go ahead and give the code. So for those of you needing CLE requirement, and this is for ethics requirement too, so I know it's an important one, I'm going to give the code. It is 39781. And I can repeat that one more time. So I'm going to give you just another moment in case you needed to, another opportunity to write that down. The code is 39781. Okay. So now I am going to, I really appreciate the discussion that Diana and Keturah just started, and I think it really leads us into our next question here, our next polling question. And I'm really interested to hear what you both have to say about this. I can go ahead and read the question, and then I'll let the two of you respond. I asked a paralegal in the firm to create a chart of the names, home addresses, and social security numbers for a list of victims of identity theft. He printed out and revised the chart several times and discarded draft versions in his home trash can. I think there was more.
There is. I've got it.
Sure.
He threw his tuna sandwich and Coke can in the same trash can, so no one would go near it anyway. But do I have anything to worry about under the rules of professional conduct, since the paralegal, as a non-lawyer, isn't bound by the rules? And the poll's up on the screen for yes, no, or maybe. And I can talk just over some of the practical implications that don't really address the question in terms of paralegal being bound or not. My initial reaction is recycle the can. But that aside, I think from a practical standpoint, it's just continuing on what we said before about making sure that people understand what are those obligations, And one of the practical things that Thrivent has done is shared information with people about what do you do when you have confidential data? How do you dispose of it properly? And we've actually made shredding services available, drop-off shredding services available, so that people don't have to, if they don't have a shredder, or they don't have something that's up to snuff for our discard, that they can still have things be discarded properly if they're actual paper files.
And I'll jump in. So yes, I think it was overwhelming. I think that we had folks who were saying, yes, you do have something to worry about. And you do. I would say this one is one of those questions where the no and maybe, I'm hoping after we talk a little bit more, you'll be converted to a strong yes. So under the rules, under Rule 5.3 specifically, it talks about the responsibilities regarding non-lawyer assistance. And just to be clear, it's assistance, not assistance. So I think a lot of people think it just applies to their assistant, but this also applies to vendors, to anyone that you hire to assist the law firm. So Rule 5.3 requires lawyers who manage or supervise non-lawyer assistants, but also vendors, to take similar actions to ensure the conduct of such non-lawyers conform to the rules of professional conduct. So every rule that you have to, you're obligated to follow, it also follows to the non-lawyer assistants. And again, if they do an action that was clearly out of the bounds of your law firm and you did not direct them to do that, you don't know about it, and you didn't have a policy about it, it would be harder, right, to get that back to you. But where there are policies, and Katura, I'm sure you must have policies. I think we talked a long time about shredding paper at home, because there are policies, and COVID is the time to go over with this remote workplace, all of those policies. So for example, Katura, I think you had a policy about how to shred paper.
Well, we've got guidelines on what you need to do. So yep. And when you're in the office, it's easy because there's a locked shredding bin and you can just go and feed it. So we had to make sure that we updated the principle of certain documents when disposed of need to be shredded, still held. But the functional, how do you do it, needed to have additional guidance because not everybody has a shredder at their house that would meet the guidelines, for example.
Right, and we actually have sort of a drive-through ability. So again, we understanding that folks maybe don't want to come into the office, but allowing people to just drive through and recycle at if it's possible, outside of your workplace. But again, organize through whatever vendor you use to be able to accept that stuff. Because after 3 and 4 months, if you've been printing, it's not acceptable to throw it in your recycle bin at home. So you want to think about those types of policies. If you don't have one, this is an absolute time to have one. And so, I think, Deb, the polling answer, if we go to the second part, it just talks more about the rule, and you'll have this to go back and look at. And it just respect to non-lawyers. So I think we can go all the way actually to supervision. And so supervision, again, we're going back over that. There's a rule 5.1, which obligates partners in a law firm, and it's not just partners in a law firm, because oftentimes I talk about law firms, I work in a law firm, but this is any legal structure. So even the internal legal departments, if you're in-house, if you are someone who has managerial authority, there are certain, you have certain obligations to assist the lawyers who report to you, and also to help source vendors and other assistants in their work for your law department. So whether it's a law department, whether it's, this is prosecutors, this is, law firms, in-house, all of that comes under the same rule. And in the context of electronic communications, supervising lawyers really have to establish, as we said, the policies and procedures, including the periodic training. So it's not good enough to say it once. And I think, Katura, you just mentioned you just had your summer training. So we have our training as well. And you have to have that periodically delivered to subordinates and anyone else at the firm about how the delivery of legal services, in our case, legal services will be had, but in general, the policies and procedures in COVID, it's a great time to set up, whether you have a Zoom, I know we all have Zoom fatigue, that's an actual word now I hear, but it's also just having 5-minute little vignettes that you can just say, hey, want to remind you of this policy, and you can have a little vignette that you send out to all of your firm or in-house or corporate employees. So Deb, next slide.
Yeah, sure. Okay, so in your materials, you have the conclusions that we already discussed from the formal opinion. So I'm just going to go through those. And we're going to turn to, I don't know, we're running a little bit tight on time. So I do want to turn it over to both of you on any other general considerations for the protection of data. And then we'll get to the next topic.
I think that we've covered generally just the kind of protections and policy updates. One thing that I wanted to add is a really effective way to get this into people's brains is to use stories. If you can use real stories and you anonymize the data, and not just stories where somebody did this and dun, 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 now they're not here anymore, but stories where the near misses, the could have been bad, but we caught it, this was a little bit outside the pale, but it's going to be okay because we, and sometimes the dun, dun, dun stories are helpful too. But I find that those stories are a really good way to explain what is it like us to do? What do we need in a structure that humans are just wired for? We love stories. And so if you can learn something, and all the better if it's a real story that happened at your firm, that's a great way to help people understand what the expectations are and what they should do if something goes wrong.
Yeah, that's great. I couldn't agree more. I think I tend to share the catastrophes more than the others, but those are all great points.
I've always said when it comes to IT hacking, you only have to look out for the guy in a sweatshirt with sunglasses on, because every time I get an email, that's the person that's trying to get in, when in reality, it's often not that person at all, right? So I think the only point I would add, and it goes back to what you were talking about, Katura, about working from home and having these confidential documents, is, I know that every employer is saying, this is your computer, do not let anybody else use this computer. And now your computer might be a lifeline to your kids going to school. You have people who are home a lot more. You might get up and someone might just want to jump on your computer. You might want to think about having, if it's a necessity to have someone else using this computer, set up 2 accounts. One that's just a sort of home user account where they don't have access to download files. They don't have access to look at every file on your computer. And that way, if you needed the occasional person at home to use your computer, it wouldn't have access to your private folders, to your email, to your VPN. You want to keep all of their activity separate, but you also really want to make sure that you restart your computer every night. Or every morning, because oftentimes what you don't know is behind the scenes, all of these ID departments are trying so hard to stay abreast of these home network attacks and everything that you're doing, and they're pushing out updates to your computer. So one of the things that I often find is somebody who has literally not turned off their computer in 8 or 9 months, because you just put it to sleep, you get back up, you put your password in, you log back in, you're not getting the downloads. So again, when you're in the office, they can push it to you in a way that they can't push it to you when you're at home. So you need to log into your VPN and you need to restart your computer. And those are just some policy point outs that I would have if you're thinking about, in terms of COVID and getting new policies.
Great. Yeah, those are all great considerations, and I had actually forgotten about the point about restarting, but I think I don't know if I know some big law firm, and I forget which one was just hit yesterday.
Yeah.
Yeah. So I mean,
had to shut down for at least I think it was at least 36 hours. It might have been a bit less, but yeah. So this is a very real, very real occurrence.
Yeah, and you know, of course, none of us want to be the person that set that in motion. So I just want to read the second course code before we get to a little bit more of the human element of this. So your second course code, and I'm going to read it twice, is 25246. So again, your course code number 2 is going to be 25246. Okay, so with that little bit of housekeeping done, in Pennsylvania, we right along with, as we were dealing with the crisis, we recognized and there's been recognition on a national level of the incredible toll that this crisis has put on many professions, but including lawyers. And so in Pennsylvania, we issued a formal endorsement of DC Bar Association Ethics Opinion 377, duties when a lawyer is impaired. So the opinion addresses the ethical duties. Of course, we recognize, and I'm sure Katura could speak to this more than I could, that this is part of a broader regulatory environment, which includes privacy, law and employment rights, and other employer obligations. But this opinion and the DC opinion specifically talk about the rules of professional conduct that are implicated. And so the specific questions we looked at is, what is the duty of supervisory lawyers who believe that another lawyer is suffering from a significant impairment? When is an attorney required to report another attorney to the disciplinary board? And what duties does a firm have if a lawyer with a significant impairment leaves the firm? So we looked at Rule 1.4, 1.16, 5.1, and 8.3. So duty to communicate, termination of the representation, duty to supervise, and the duty to report. I'm going to turn it back over to Diana to talk a little bit about the responsibilities of partners and managers portion. Diana, I think you're still on mute.
Well, it's good, because what I was saying is we already covered this in the security context under Rule 5.1, which requires that the partners and managerial lawyers must make reasonable efforts to create and maintain effective measures to ensure that all lawyers conform to the rules. So that 5.1 is directed to other lawyers. The 5.3 that we talked about earlier was directed towards non-lawyers. And so, you think about, and Deb, we want to keep moving on, what constitutes like a reasonable effort or assurance. So there are no written rules in these opinions that tell you exactly what you need to do. But the recommendations are that, it doesn't need to be in a written policy, but of course that's useful. The policy can provide for an anonymous reporting mechanism and steps for the firm to take. And the policy provides consistency in the handling of difficult situations. And creates a culture. And I think that's the key that I kind of want to zone in on. We're going to give you the slides so you can read through this. But I think what's really important about this discussion, to bring it in really early, is that cultural aspect. And Katura, would you mind talking? Because we had a great talk about just the culture, the idea of that.
Sure. So one of the things that I talk about is creating a speak up culture. You want to have a culture where people feel like they can raise questions or concerns. And this starts with things that might seem stupid and kind of small, like, do you make fun of somebody when they first start and they don't know what all the acronyms are? And when they ask about it, do you smile and answer, or do you smile in a way that's like, you're dumb, you're new here? Even little things like that go on the path for, is somebody going to be comfortable to bring up a more significant question or concern? So we talk about creating speak up culture. And then one of the other things that I wanted to address is just, what does it mean to be an upstander? I think one of the things that I've seen in my 15 years is, particularly if somebody has a concern about misconduct or potential misconduct or an impairment in this example, with somebody that they work with, they probably care about them to some extent. It's somebody who's a colleague, maybe a leader, their manager, a senior partner, etc. And what do you do? And I think that it's a really normal human feeling to want to protect people we care about. But I want to challenge you and maybe encourage you with something that I heard from a judge. This particular judge, it was a panel where judges were matched up with white-collar criminals who had served their time and came back, and then they had this really interesting panel of 3 pairs. And one of the judges was asked, how do you decide what to do when you're judging? And she said, it's not my job to decide whether the person is sorry enough, whether the person isn't going to do it again. She said, my job is to adjudicate the law. And if they have been convicted, then it is my job to issue a fair sentence. And so that's how she looked at it. And it was like this, that was early in my career here, but it was kind of like this weight had been lifted off of me. And I thought, oh, I'm an investigator and I'm just finding the facts. And I'm making sure that I don't have to be the judge in that case, but what my job is to make sure that the right things get reported, that I have a system and mechanism for doing that, that we understand the facts and that we take appropriate action based upon those facts. And I would encourage any of you, if you see somebody who has an impairment, not to be worried about being a snitch or a rat or any of the more negative words that we put on it, but know that you're being an upstander. You could, by virtue of sharing that, stop somebody else from being hurt, stop a bad situation in the middle of happening, provide an opportunity for that individual to get help that they need to address whatever the problem is that's causing the impairment.
Yeah,
go ahead, jump
I was
right
going to
back
say, I'll
in.
come in and be the dun, which says that you also have if you're a lawyer, and this is someone at your firm, you have an ethical obligation to speak up and say something. And one of the mechanisms, as you said, that you don't necessarily need to say this person has an impairment or doesn't, but if you have the right mechanism at your firm or at your place of business, it might be to hire an outside a doctor to come in and assess that, and to go to the right professionals who can help determine whether this impairment is present or not. But it is your duty and your obligation, especially if you're a lawyer, you have to say something if you see something, because it could be affecting client work. So Deb, you want to go with polling question number 4?
Yeah, sure. And just in the interest of time, yeah, if we could put up the polling question. Do you want to go through that, Diana? Just read through it. And
oh yeah, can I use my personal and professional judgment about reporting a lawyer who I know has misappropriated client funds because of a drug habit? For example, may I speak with a lawyer and try to set up a plan to get into counseling, or try to pay the client funds back instead of snitching on the lawyer? Yes, no, maybe. I think we can move pretty quickly. We'll stop wherever we are. I don't see, we haven't got the results yet, but I'll just, spoiler alert. Okay, we're good. Yeah, no, and no. And Deb, I know you felt strongly about this one because this is an example that we've discussed before.
yeah, I mean, this is painful, and I mean, they call it, you know, I know, Katura, I think you used the word too, snitch. In Pennsylvania, they call 8.3 the rat fink rule. And so, I mean, it does have some, you know, this kind of reporting has some negative connotations. But under Rule 8.3, we're talking about the model rules. You obviously want to check your own rules. As a lawyer, you have a duty to report this type of professional misconduct. And the rule is right here for you. So yeah, that one's a really, that one's a painful one.
And can I say one
yeah.
one quick thing that can sometimes make it a
Sure.
little less painful? In my 15 years, I've been with hundreds of people who have reported and have walked people through that very difficult, in your face. It was one thing to be hypothetical that sure I'd be willing to report, and another thing to actually do it. And I myself have had to report something. And at the end of the day, with the thing, when I sat and had to report my thing, I thought, my ethics and my integrity are important to me. And it is critical that I do the right thing and trust the process to do what the process needs to do. And so I would encourage all of you, I don't think you want to be on the other side of it. If somebody comes and says, you failed in your professional duty, make sure that even if it's hard, it is worth doing the right thing.
Yeah, that's great. I'm glad you brought that up and brought up some of the positive side of this. We do have a slide in your materials for Lawyers Concerned for Lawyers. That's a 24/7 hotline to provide assistance for those needing help.
And I'm sure that, you know, if you're working at a corporation, or there are going to be these numbers that are provided, and they are anonymous, to a certain point, I think. But they ultimately, it's about doing the right thing and about giving you a platform where if you just don't know where to turn to, you can start there, and they'll take it from there.
Mm-hmm. So we just have a couple more polling topics that fall under this hot topic. So Katura, do you want to walk us through this one?
Read the polling question? Sure. Do you know if your company, firm, or organization has a policy regarding social media posts on your private account and other private activities that may reflect on, I assume it says the firm, the company. For Thrivent, I'll just say what we do have. We went through this. There was a spate of things that we dealt with in short order, multiple issues this summer, and I think everybody's feeling a little stressed out, and some people take that stress out by posting things on social media. For us, we do not We do not go searching and looking for somebody's social media accounts, but I put together a training this year to clarify that if somebody brings it to us, as has been happening, if you read any kind of news articles, there's plenty of people who are going to go out and figure out where somebody works. If that comes to us, and if we deem that whatever the action or the post is violates our values and who we are, Thrivent may choose to separate from the individual. So that is an option. People are free to post what they like. We are also free to say that goes too far. And if it's in the sort of thing like inciting violence, if it's racist, use of the N-word, for example, is one of the things that we have said, this is the line, you cannot go there. And we will choose to separate from you. So it's good to get very clear, I think, as much as you can before that comes. Hopefully it doesn't come, but if it does, to know what it is and to have laid out those expectations is a better position to be in than trying to say, oh my goodness, what do I do? We're the latest viral video that's going around.
Absolutely.
That's great. And then we have one more polling question. Diana, do you want to run through?
Yeah, it says, do you know, yeah, I'm off mute. Do you know your company, firm, or organizational's policy regarding in-person meetings? You can throw that up. And this is in the context of both COVID, but also outside of this environment, but also, you know, in terms of having Zoom meetings, right? Like if you meet up with someone on Zoom, are there certain policies? Because there's something that you can do. I know, you know, there's a wine tasting after this. Could you host a wine tasting with your client or vendor? So those are sort of the things that have been coming up a little bit. So majority of people are saying yes. Sure. Could you talk a little bit about, I know this comes up in your context a lot about folks trying to get.
Yep.
Yeah.
So we've got financial reps, and obviously they're wondering what can I do in terms of meeting with my clients or things that I would have had for business entertainment. So we, back in March, posted some guidance about what does it count as a gift or entertainment if you're doing food over Zoom. So we put together a whole guidance page on that to help people navigate, and talked with different business partners to make sure that what guidance we were putting out was actually what kinds of guidance they needed. The other thing that we've talked about is we're not having in-person meetings at least until January, and that information has gone out. But we got a question from somebody saying, well, what about a golf outing? It's outside, it's for work, and normally it would be the kind of thing that wouldn't even be a problem. But we aren't willing to take that risk on for somebody going to an event where they're probably going to go in the clubhouse. They may eat inside. You're going to have to use the restroom during that time. So that's something that we are saying no to for now. At the same time, if we need somebody to have a war room document review, we can approve things, but that individual is going to have to go through our review process, and they're going to have to follow the guidelines that we set out, which can include things like you can fly in and out, and you have to wear a mask at these times, and it needs to be only you, and that, et cetera, et cetera, et cetera, because that principle of ours that I spoke about at the beginning of valuing people still holds through all of these.
Absolutely. And I think, and as you're saying also, just being upfront and thinking about, okay, let's have a policy on this. We know it's happening, and we'd rather have, you know, a document that saying that culture of here's what we're going to create. This is what we're thinking about. But I'm telling you, as you know, being at a firm as well, and leading some of these requests, you know, it became very clear very quickly that we needed to have policies, because if one person is asking, we say this all the time in class, Deb, if one person's asking a question, 50 other people are thinking it. So, you know, really having this and taking a look at your policies and deciding that, and not making exceptions for, you know, certain people, right? Like you have your policy, you're thinking about the good of individuals, and you have to just go with that. I know we're right up on 5 o'clock, Deb, so I'm not sure if there's some,
yeah, well, sorry,
Okay.
one real quick thing. We've got box coronavirus. So I think also making sure that people know where to go to ask. Do you have a place inside, whether it's a new thing that you create or an old place where people could ask policy questions? You could use either one, but make sure that somebody knows, and who do they go to when you have these one-off questions?
Absolutely.
Yeah, that was actually going to be my question. So if you're in an organization, what would you say, Katura, is the best way to find out the answer to this type of question?
To this type of question, I would think if you have some kind of a response team like we do, so that's our box coronavirus.
Yeah, right, that's great.
Box code of conduct internally for me is the hotline I run, which is always if you have a policy question, you don't know where to go. So I have 15 years of telling people, so we've gotten questions in, and then we coordinate. And then also our HR hotline are the main places that we've seen questions coming in. So
Yeah, no, I think that's really, really helpful, and people can get started from those places. So at this point, I wanted to thank you both for being here, and
Welcome.
thank everyone for joining us today. I know that we are the one thing standing between the conference and wine tasting. I'll turn it back over to Michael.
Very much. I'd like to thank Deb, Diana, and Katura for the presentation. It was very helpful. Before parties depart, if we can just make an announcement, although we've been advised that the outage with respect to Attendify is temporary, we are going to pivot to Zoom tomorrow. You will see an email with invitations to the panels later this evening, so please keep your eye out for that. That will have the link and the relevant information for each of the panels. Apologize for the inconvenience, but certainly confident that Zoom can come to the rescue like Nick Foles did for the Eagles.
Thank you. We need him back.
And that is it. Appreciate everybody's time, and thank you very much.
Thank you.